Hey everybody, this is Wake Up Call Live. I am your host, Christina Previtt, and joining me today is trademark attorney Francesca Witzburg. She is going to share all the deets with us about Kim K's trademark problem. Welcome, Francesca.
Thank you so much for having me, Christina. I'm super excited to talk all things trademarks and Kim K.
Excellent. It really is an interesting topic. I myself, as a business owner, have had run into this issue a few times in my practice and my podcast. So I've taken a new interest in it. But I love all things Kardashian. It's my guilty pleasure.
We all do.
And yes, right? And Kim K is so fabulous. I mean, she really is a lady boss. You know, she's got numerous businesses. She's built an incredible brand, and she's still got new brands coming out. In particular, as some of you probably know already, she had her beauty line, the KKW Beauty brand, and she's rebranding it. She's taken it completely off of Instagram. I think if you go to the website, there's probably just a landing page there now. And she's, I think, combining that brand with some other things, like a new home brand, I think is what's coming out. And she applied for a trademark. I've seen this in the news. I think it's going to be called Skin by Kim. Mm-hmm. It's SKKN by Kim. But apparently there's somebody else out there already who has, I think she's an esthetician, and she has spa services. And she's been using SKKN Plus as her brand. So what I've seen in the news is that she has filed a cease and desist, and you're going to explain to us what that really is, to prohibit Kim from using that brand name. So I think this is really fascinating, especially because it's, Kim K, like this huge conglomerate, against someone who I think has, a relatively small business. Yeah. So that's the rundown. If you know any other details, please tell us. But let's start with, what is a trademark?
It's a great place to start because, we use the term all the time, but I'm actually going to take it one step back and define intellectual property, right? What is intellectual property? Intellectual property refers to creations of the mind. So within the realm of IP, I like to say that people have various IP tools in your IP toolbox, and IP is short for intellectual property. So one of those tools is a trademark. Trademarks protect names, designs, they can protect smells. It's basically anything that indicates to consumers who is behind the particular goods or service. It's why when you see the golden arches, when you go to any foreign country, you could go to Madrid and see them, who's behind those hamburgers. So that's the function of a trademark. Copyright protects other types of creative works like literary works, photos. Then there's patents and trade secrets. But today's conversation's focused on a trademark. So a trademark, as I said, they are source indicators. You use them to point to you and to differentiate your products or your services from those of others.
Okay, so in this particular case, Kim is trying to trademark the name. I'm going to say Skin because I think it seems obvious that's how you pronounce it. Skin by Kim. So I don't want to get into the difference between a copyright and a trademark. That's just my lawyer brain, just going haywire. I think our audience probably doesn't need to get that into the weeds. But for Kim and her team, I'm assuming she's got a team of lawyers that have been working with her on all her various business interests, the intellectual property being one of them. So let's say you were representing Kim and she said, "Hey, Francesca, what's up? I want to start this new beauty line and coordinate it with other products." Mm-hmm. What would you have done as her attorney?
Yeah, so I actually do work with a lot of celebrities. It's not necessarily them emailing me directly. Sometimes it is, but it's usually their agent or their manager. And it's very streamlined, right? And especially for people like Kim Kardashian who have their stuff together. These are businessmen and women. So they understand the value of trademarks, and Kim Kardashian is not a person that's just going to go and randomly think, I like this name and I'm going to start using it. She is a target. She's a target in media. She's a target legally. So of course there was, I would say that there was some due diligence that went behind it. And so I want to explain to people the process, because it'll make us understand how sometimes these things do happen. So if a client comes to me and says, Francesca, I'm rebranding, this is going to be huge, right? This isn't just a random slogan I'm going to use for this month. This is a multi-million-dollar brand that's on the line. It's going to be very visible in the United States, and she's international, so abroad. So we would actually do what's called a trademark search. The first stage is a preliminary search. I call it a quick and dirty search. It's to just check the USPTO for very similar marks and check Google and then maybe some other online sources, but it's very high level. It's basically skimming the surface to see if there's immediately someone with that exact name for the exact goods and services. The problem, though, is if you're doing an internet search, checking page 1 of Google just isn't going to do it. And that's what those searches pretty much do. They're not deep dives. So it is always recommended to do what's called it's a further search called a comprehensive search. These are searches that are mostly conducted by third-party companies. So I will work with a vendor that has a team of researchers to not just check the USPTO more expansively, maybe not just for similar names, but for words that have the same meaning that, frankly, my software wouldn't pick up. And then they do a deep dive in the common law databases, which is not just Google. It could be all types of social media, any type of online record or physical records. These are much more extensive searches to look for people that do not have registrations but are actually using the mark in commerce. And that's the key. Because in the United States, if you have a trademark in the United States just by using it. That's the way our law works. However, those rights are limited. They are limited to the geographic region really where you operate, which gets dicey with online businesses. What does that mean? So the way you get around it is by filing a registration, because once you have the registration, there's a presumption of rights in all 50 states. So you don't have to say, oh, my rights are only in this one territory. Once you get your registration, government gives you a document and says you are the exclusive trademark owner in all 50 states. So let's say we did the comprehensive search. Sometimes, I think 2 things could have happened here, tying it into Kim Kardashian's case. These are not foolproof searches. They are just not. There's so much data out in the internet that it's possible that it did not show up in the comprehensive search. I would say it's unlikely, but that is a possibility. That's why lawyers have insurance. That's why these vendors probably have insurance, but pretty much they are deep dives. So what also could have happened here is that it was disclosed in a comprehensive search. And at that point, the person and the brand needs to make a decision. That's where we come in, Christina, the lawyers, to get on the phone and walk through the search report with a client and say, here's the risks involved. Because the reality is my job isn't to tell clients what to do. My job is to ask clients their risk tolerance and explain to them the level of risk that's associated with a mark. And when you see an exact mark for the exact goods or services on the register, or maybe not even a registration, if it's a common law use, that is a red flag. That, to me, I tell clients, this is an extremely higher than normal risk, but I'd never say no. Like, I work with a lot of celebrities and brands that say, okay, but we want the name. So how do we go about getting it? There's a variety of different strategies. You can approach them. You could do an anonymous approach, so it's not Kim Kardashian's, brand. You can hire someone to say, I'll pay you $10,000 to obtain the rights to the name. Maybe they're not using it anymore. There's a variety of different things you can do. Sometimes clients will say, well, he or she, the person using, is very small, and it looks like they're only in this niche market, which is what's happened here. She's an esthetician in Brooklyn. And let's just file and we'll deal with her. We'll negotiate when it comes around. That is a very common strategy for deep pocket clients that fall in love with the name, they fall in love with the mark. They think, okay, we think that we're able to differentiate our products and our consumers. And I think that's why she did SKKN with By Kim, because adding Kim, they probably thought would help distinguish it. But from a trademark law perspective, just taking someone else's name and adding something to it really isn't enough. So I don't have a crystal ball, but based on my experience working with celebrities, I do think that it came up in a search report. Maybe there was a business decision to actually go ahead with it and negotiate with this business if it became a problem. But unfortunately, and this is something I advise clients too, when you are a big name, you are a big target. So it's not just a matter of cutting people a check sometimes. If they go to the press, and if you read the headlines, a lot of them have made it sound like Kim is steamrolling on this small company. So whether or not that was the business that decided to make a PR move to try to get publicity from this, because that happens sometimes, or they're just angry and they wanted to tell their side of the story. That's the reality when you are a big brand or a big celebrity. You're under the microscope. If you make a decision to try to file and negotiate, that may not be the best option. Sometimes it's better to approach before you start using. I know I just went really deep, Christina.
That's okay. I mean, you really answered like everything that I was thinking in every question, mostly. I want to back up a little bit though. So initially you would, do the search and you would make the application, but a little bit of a nuanced question for me, and this is personal too, because I know I've come up with this question like in the past in my own personal matters, but do you have to already have that brand, like let's say skin? If you're making the application, do you already have to have been using that in your business? Which in this case, Kim really wasn't. She wants to use it. So
Sure.
Is there a distinction there?
Yes, there is. So, and I want to point out that they didn't file, Kim and her team didn't file just one application. They filed 20 and 20 trademarks in a variety of categories. One of them is candles, which is going to your like lifestyle, broader, and she's going to use this for home goods and things like that. It's not just skincare, but all of them, I believe, at least most of them, I'm looking, were filed based on what's called an intention to use.
Okay.
The government allows for that. As long as you have a real, it's called bona fide intent to use, meaning, you've worked with, maybe you're in talks with vendors, you're in talks with manufacturers, you really want to produce this product line, you can go ahead and file and preserve your spot in line with the government.
So what happens then? You said you do a search and you look for it. I was thinking you look to see if someone has already trademarked it, but you were saying that you look to see whether someone's using it. So someone can be using it in their business, but it's not trademarked.
Yeah.
So, that to me, I would think as a layman when it comes to trademark issues, because that's not what I do in my area of law, I would think that if you didn't trademark it, well, you're kind of out of luck. You should have trademarked it, but it sounds like that's not the case.
Yeah, I think there's a misconception. This is where like the misconceptions come in, where people think that you need to have a registration in order to have rights. That's not the case in the United States. Some countries it is, but in the United States, when you say, Christina, trademark, like as a verb, you trademark something just by using it. So the second that you actually start using a name and you start selling to real customers, you have a trademark, okay? When you go to file for the trademark, that means you go to register a trademark. So there's two separate rights. There's unregistered rights, which are called common law. And then there are registered rights, which you have to actually file for. So there is that misconception that to trademark something means to file, but that's not true. You have rights just by using them.
So then what is the point, or what is the value then of actually trademarking something?
It's a huge value, and I will make this super clear for everyone watching because it is so important. If you rely on common law rights, your rights are only limited to the geographic region where you operate. So that means if you are a fruit stand in New York City and you are only servicing New York City clients, maybe, you could argue that it's New York and the greater states around that are coming in. However, we're all digital. We're all online businesses. We're marketing, we're cross borders, not just the United States. We're cross international borders. So when it comes down to it, if you don't have a registration, you do not have that presumption of rights in all 50 states. If it becomes a battle, you literally have to prove to the other side where your customers are, where you market, and where you have rights. It is expensive, it's exhausting, and it's pretty much a he said, she said. And as you know, and as most lawyers know, and anyone who's ever had to deal with litigation, it's really, really stressful and expensive. So the way that you get around all of that, right, is you just file for the trademark. It is not expensive. They are affordable. And when you file, you are now preserving your spot in line, and you are telling people, you're putting them on notice, so that had this company had a registration, I would bet that she would not have picked this brand, because they were definitely claiming rights in all 50 states. And you're doing two things. You're saving your spot in line, but you're also putting people on notice. Then once you get that piece of paper, Christina, that's where it matters. When you have that federal registration, it is so much stronger than any rights that you could have just by using in the United States.
Good. Thank you for clarifying that, especially for me. So when you say geographic region, what do you mean? Do you mean your state? Do you mean your neighborhood? In this particular case, this woman has her business, I believe it's located in Brooklyn.
Mm-hmm.
So what would that mean to you in terms of geographic region?
Well, with all things in the law, it depends, right? And the way that the law is written, I really emphasize that geographic region, right? Like, what does that mean? What does that mean for businesses that are on Instagram and online? I think this is going to be one of the biggest things that we're going to see in the next 15, 20 plus years of the trademark law trying to adapt to online businesses, because that standard used to work when there was no internet, right? If there was a small shop selling clothing in Florida, there wouldn't be any consumer confusion if someone was operating in Seattle, right? That's because they were two different markets, and it was likely that the consumers were kind of set in their particular areas, and it was a low likelihood of confusion. That has all changed because of Google and Instagram and the internet. So I think we're definitely going to see more of that. And so that's why I tell everyone, just file for the trademark. You do not want to you don't want to get in a pissing match with another person spending hundreds of thousands of dollars just trying to prove where in the country you have rights.
Well, I definitely don't want to get into a pissing match with Kim Kardashian. She has way more money than I do.
Yeah.
Okay, so I've read in the news that there is a cease and desist order. That was the exact language. Now, what is that, and what does that accomplish?
Yeah, it's funny. I love being an expert reading some of these news articles. Sometimes they don't use the right terminology. So it's a cease and desist letter. It is a letter that she received from the other side telling her that they have prior rights, probably attaching some sort of evidence in her social media pages and putting them on notice and demanding that they cease and desist, so they stop using the trademark or whatever it is that she plans to do, or else that they're going to sue her.
So how would they have been alerted to it? Because she just filed. So if somebody files, I guess if she's not trademarked, it sounds like the lady in Brooklyn is not trademarked, or we probably wouldn't even be talking about this right now. So how would she have been put on notice of this?
So the woman in Brooklyn did not. She filed an application after Kim, after she found out about it. But so, I mean, this is an easy one because it's just all over the news. Like imagine if Olivia Rodrigo, sorry, she's the only person in my head, started using like Wake Up Live for podcast, right? You know,
well, I would have to retain you.
We'd have to send her a letter. But you would think, oh my gosh, that's my name. And like, no. So definitely that's how they found out. And
yeah.
Whether or not they leaked, couldn't find the letter online. As a strategy, you know, when you are a smaller business, you use the court of public opinion. That's what they're doing. Read all the headlines. I'm not going to say that they went to the news, but
yeah,
lawyers tell clients, and clients do that as a strategy all the time, to use the court of public opinion.
Oh, yeah. I mean, if I was her, I would totally do that. I would totally use this as an opportunity to market my business. Even if she doesn't really have any care in the world or any intention of actually trademarking it, although it sounds like she does if she did file something. So what happens then? You know, what is Kim's recourse at that point? She can ignore the cease and desist and just keep going about her business. What else can she do? What are the options at that point?
Yeah. So, and with like going with the court of public opinion, I think this is totally a leveraging. Like, so regardless of PR, you know, a PR show, this is leverage. We're talking about this right now. Like they are leveraging all of this so that they have the ability to go and negotiate with her. Because sometimes clients will say, let them sue us. They're not going to sue us, you know. But when it becomes a big thing, now Kim's brand is at issue. They're making it sound like she's steamrolling, you know, a small business, which nobody wants to be seen as that. So they're definitely going to settle this. This is going to settle. I don't think, based on what I see, this is one that would settle, and most cases do. So it'll be interesting to see where they land. Maybe they have some sort of coexistence agreement, but because the marks are so similar, I'm not sure.
So I believe the woman's name is Cydnie, who owns the Brooklyn shop. If you were representing her, what would you tell her to do? I mean, what would be some strategic options that you might float around?
I would do exactly what she did. Immediately file the application, claiming rights back to the earlier date. I would go to the court of public opinion. I would put it in the media that my brand has been stepped on, so that I have that leverage. And let's see. I mean, if SKKN plus is really important to her, she may not budge. But when you're Kim Kardashian and you have that much money, a check may be cut. And I feel like a deal will be made here.
It could be a big check. I mean, how much, do you have any idea? Like, how much would you ask for?
Oh, it could be, I mean, it depends. I have seen them all over the place. It could be hundreds of thousands. It could be higher, you know.
I was thinking $1 million or more. Would you be like, Christina, stop it now. Let's not get greedy.
You never know. It'll depend on how bad they want it. And that's why approaching people first before you start using and before they find out that it's a big celebrity is a great tool. So you write to them anonymously and ask to buy the rights. You offer a pretty good amount. You know, you can offer anywhere from like 5 to 25K to start. You know, I've seen it higher, and people will turn over the rights. And then that way you have the rights. They can't come back and say, well, I didn't mean to sell it to you. And then you kind of avoid these issues.
So they both have applications pending.
Now,
And yes, and they could talk. Their attorneys could be talking now for all we know and trying to resolve it. But if they can't resolve it, what will happen?
yes. So the demand letter usually makes a threat of litigation if they don't cease and desist. So the Brooklyn company will probably sue Kim Kardashian. Let's see. Yes, it would probably be in federal court, and the argument is reverse confusion. This is the standard is typically whether or not a consumer is likely to be confused, but there's reverse confusion here, which is when a little company starts using a name, has developed a market for the brand, and now all of a sudden a bigger player comes in. So she's been operating in Brooklyn for a long time. Now people are going to be confused. They're going to think that Kim Kardashian's brand is somehow affiliated with her brand, and people don't want that. So that's really the legal argument. Like I said, rights, trademark rights are based on use. This would have been a much easier case if the Brooklyn company had filed before, but because they had not, now they are going to have to show where their rights really are in the United States. And it'll be interesting to see what happens.
It will be. I'm watching it. Do you think that she's not likely to prevail? Cydnie, I keep saying her name wrong. Cydnie, do you think she's not likely to prevail? Because if she, and I don't know the extent of her business, but if it is just limited to a local spa in Brooklyn and she's not really selling merchandise, and, you know, obviously people probably from California are not flying out to Brooklyn to go to her spa. It's, you know, something local. Do you think she's not likely to win?
Well,
if that's the case?
That's totally what the Kardashian legal team will argue. And the other side, though, is we're all online. She could be going virtual now, which a lot of businesses did in the pandemic. They offer like free esthetician classes or virtual, you know, Zoom type facials where they walk you through. And so I think that that's something that we definitely are going to see in their argument, is that we're actually marketing and servicing clients all over the 50 states.
Okay. Well, will she get crushed in legal fees? So if she came to you, is this something you would charge her hourly for, or would someone do a contingency fee?
That's a great question. I don't know many trademark lawyers that will do contingency. The attorney for the Brooklyn brand is actually someone who is also a big Instagram attorney. He does a lot of things. He has a podcast too. So I don't know what his payment structure are, but if it were to come to my firm, most lawyers do charge hourly. So yes, it could be something that is expensive for her, but maybe the attorneys will work something out with a settlement. Like I've seen all types of things where it's hourly, but if the chances of success look good, they'll get a credit back and get a percentage of the settlement fee. They kind of work out a deal that way. So
in this case, it's not just a given that Kim will offer something. She might just say, no, we'll litigate because I'm confident that I'm going to win. So in that case, the attorney would end up with nothing.
It's possible. Most cases in general end up settling. Most trademark cases, people do not want to spend, even companies that have the money, they just don't have the time and energy to invest in trademark litigation. As much as I love my job, sometimes it's not the most pressing issues that's ahead of them. They don't really want to budget for that. So, but I think there's definitely wiggle room and her lawyers are going to be fantastic. So
I'm sure.
I see her maybe sending a response. Actually, I don't know. Because then with PR, I don't know how she's going to respond, because she will want to. The headlines aren't looking good for her. So it would be interesting.
For who? For Kim or Cydnie?
The headlines don't look good for Kim Kardashian.
Yeah, they haven't been putting it in a good light. You know, you're right. Like this big company, someone with really deep pockets is essentially stealing someone else's name. I mean, I don't know if that's actually the truth, but that's the way I've seen it. They're spinning it in media. All right. So, well, thank you. This has been very enlightening for me. I am very interested to see how this evolves. And I hope Kim will do the right thing. You know, we're all women, just lady bosses, right? So is Cydnie, just working her business. And I want to see her be successful. And I want to see Kim continue to be successful too, because she's an inspiration to all of us who have our own businesses. So is there anything else that you thought of as you've been watching this in the news that I didn't ask you that you want to share?
Why is this relevant to us and for the people watching and for all businesses? It doesn't matter if you are a service provider, if you are an online business, a physical business, every business has intellectual property and needs to protect their intellectual property. Think of it as your insurance policy from crazy expensive litigation. It costs a fraction to just file your trademark, get rid of all of that geographical region limitation, and just have peace of mind that you have your rights and that your stuff is protected. So everyone should talk to a trademark lawyer.
Thank you for that. Well, and for people who are watching who may be saying, because I have a lot of women attorneys in my audience, they might be saying, well, I own a law firm. I mean, what am I going to trademark?
You'll see it. I have my own trademarks for my law school programs, and it's important with everything becoming much more digital and virtual. It's very important to protect.
All right. Well, you heard it from her, ladies. Reach out to her, find out what you need to trademark. You don't know what you don't know. And we want you to protect your business. And you can find her at the Trademark Attorney on Instagram. And is there any place else that you would want them to reach you, or should they just find you on Instagram?
Find me on Instagram. If you want to learn more about intellectual property, or if you have questions, click on the link in my bio and I offer a free consult.
That's awesome. All right. I just put that in the comments so you can find it in the notes. And thank you. I really appreciate this. And I may invite you to come on and do it again if you can give me some of your time so we can see how this evolves.
Definitely. Thanks, Christina.
Thank you. Thank you for watching.